And welcome to the Week 9 assignment video. This video is going to talk about the assignment that we have for Week 9. It happens to be the most difficult assignment for students because it's not really something where we have form language to help us. It's not something where we can check a box like we see on the interrogatories just by deciding what might be relevant to the action, that kind of thing. Those are generally much easier because we don't have to write something down. What we're doing here is we're going to request documents from the other side under a request for production of documents, which is one of the discovery tools that we talked about and learned about as sort of like a subpoena for documents, but it's directed to the opposite side in a civil lawsuit, and it requires the other side to give us all non-privileged documents that fit our description. Now, what's very important about this request for production of documents and discovery in general is if you don't ask for it, you don't get it. So you have to be very broad in your requests so that it'll cover just about anything that they might be hiding from us, but not so broad that it'll cause an objection for something so overly broad as to be everything in the world. So, for instance, you wouldn't ask for instance, every email that a person has ever had sent or received in their lifetime. But you might ask for that if you simply ask for any and all emails you might have and not realize that you're asking for much, much more than is justifiable under the discovery rules, because you have to justify your request so that it is reasonably calculated to lead to the discovery of admissible evidence, even if it doesn't always do so. It just has to be calculated to do so. It means it has to be well thought out. So you're going to be doing some wordsmithing here on this assignment. And that's what is the more difficult aspect of the assignment. So I'm going to help you a little bit by giving you some suggestions for some of the requests so you can get an idea of what kind of language you should be using to get what you want. Because again, most likely, most students will ask for way too much and call for an objection that will simply make it so that we have to ask it all over again because we ask for too much. If we ask for too much, they can object to it. They don't have to give us anything. And we can't really go into court to ask for the documents we've requested because we obviously asked for too much. So we have to be very careful in our language that we ask for enough to catch anything that might be hiding from us, but not so broad as to cause an objection. That's at least a good objection anyway. All right, let's look at the graded activities for this week. So we can look at the assignment that we're going to have. Make it even more understandable exactly what's going on here. Now, you're going to assume the same situation as provided in the notice of deposition assignment you completed earlier in this class. You are now tasked with preparing a draft request for documents to be propounded to plaintiff John Smith. Now, it happens to be that John Smith is the person who was beaten up, I think, at the Walmart on a Black Friday. And we're claiming self-defense. We're going to look for, and it says right here, you're going to look for categories of documents that would tend to show that John Smith is a potentially violent personality. Now that's character evidence. If you take my evidence class, normally character evidence is excluded, but just because it might be excluded doesn't mean it's not potentially admissible under certain circumstances. So we can get it if it's character evidence, so long as it's reasonably calculated to lead to discoverable evidence, to usable evidence at trial. So we can ask for character evidence stuff, and the judge will ask, make sure that we get it if it's legit, and this would be legit here under the circumstances because we're trying to say this guy went off like a bat out of hell and was coming at us, and we had to defend ourselves, and that's the reason why he got beaten up. Rather than we just beat somebody up because we wanted to get whatever they were trying to take away from us at Black Friday. All right, so please use your critical thinking to define as many categories of potentially relevant documents you can think of that would require John Smith to deliver to your firm all documents that have a tendency to show that John Smith is a violent person. This would include, but not be limited to, journals, police reports, letters, newspaper articles, etc. You also want to request all documents that show that John Smith was insured for any liability that could have resulted in the altercation between him and your client, Jeffrey Jones. That's because you want the insurance company to pay you, just in case John Smith cannot pay you. And you'll be graded on the quality and completeness of your descriptions of the categories. You will also be negatively graded on whether your categories are overly broad and that they cover documents that are clearly not relevant to the lawsuit. That means that you're not even calculated to lead to relevant evidence. You are actually calculated to lead to just giving documents that have nothing to do with the action. All right, you're going to post these categories in a Word document, and then you're going to post it in the Canvas online classroom, even though it still says D2L here on these older modules. In any event, this is what's going to happen. You're looking for two different general categories of documents. First is every kind of document you could think of that John Smith may either have or has the ability to get his hands on that would indicate that he's a violent person. So just as an example, let's say John Smith has had a criminal case in the past where he beat somebody up, and there's a criminal police report that's been written on him. He may either have a copy of it, or he knows where to get it, and he's allowed to get a copy of it, so it's within his control. And so we can ask him to go get it for us, even if he doesn't actually have it right now. There may also be letters where someone accused him of being a violent person, or letters where he was violent with somebody else and threatened them and that sort of thing. There could be newspaper articles where he was, there was an article on some sort of a violent act or a violent tendency, that sort of thing. So we're going to have to look for individual categories, but we want to ask them in a very creative way to see how many of these categories we can get so that we can catch anything this guy might be hiding from us. By the way, that also includes his own personal journals. If he writes in a journal, some people do. We'd want to get those things. And so let's look at actually some real requests for productions of document wordage in terms of how these things are worded. So to give you an idea that that the definition that we put in the things we request is what we will get. And so again, it has to be broad enough to cover anything they might be hiding from us, but not so broad as to be objectionable and excludable because the judge finds out we were asked for too much. Again, if we ask for too much, we're in trouble because we can't enforce it. We're basically having to ask it all over again and do it right the second time. So we want to do it right the first time. So let's look at some actual, these are actual requests that actually are online. And some of these are very, very simple and some of them are more complex, but look at this. Please produce the documents in your possession, custody, or control. That's a good way to start almost any of these requests for documents. Because what that does is the word document has already been defined up here. Document includes writings, drawings, graphs, charts, photographs, phono records, and any other data compilations which information can be obtained, translated, if necessary, by the responding party through detection devices. Actually, there's even a more broad statement under California Evidence Code actually defines what documents are. And if we simply use the term documents as defined in the California Evidence Code, we will have everything. It includes audio tapes, videotapes, any way of putting any information into a recorded form of any kind. And so that word document then becomes a very generic term. It could be anything. It could be that he has a video, but he doesn't have anything written. Well, we're going to get the video because we use the word document. See how the definitions are so important to getting what we want? So we don't want to have to keep putting writings, drawings, graphs, charts, all that into every single one of these. So we just simply put the word documents, and then we put it in all caps. In California, it's required to be in all caps rather than in just caps, as we see here. This is actually out of Nevada, so their rules are a little bit different. But whenever we have a term that means something specific in our request for documents, then we have to put it in all caps, and then we have to define it somewhere in our instructions so that people will know what we're looking for. So again, I would implore you to use the word documents, put it in all caps, and reference documents or define documents as that defined in the California Evidence Code. And then you'll have everything you need there. So please produce the documents in your possession, custody, or control. These are important words: possession, custody, or control. That means either he has them right in his own possession, he has them physically with himself, or he has custody of them, meaning he has the right to control them because he's given them, but they're not necessarily his documents, but he has them because he has custody of them for somebody else. If that's the case, we get it. Or control, which means it's possible some of these documents may be within the possession of one of his vendors, for instance. But if it's in the possession of his vendors and he has the right to get his hands on it, then it's within his control. And so now we're picking up documents that are not only in his possession, but in his possession that are not even his documents, and documents that are something that are accessible to him in any way. So under the word control, we would also include documents such as police reports of incidents involving him. Whenever you have an incident involving you, you can get a copy of the police report by simply requesting it from the police station, probably paying a fee, but you can get it. So because you can get it, it is within your control. And so we get that language in here. So here's the please produce the documents in your possession, custody, or control which support your responses to the interrogatories served concurrently herewith. What's happening here is they were sending a set of interrogatories along with the request for documents. And then they were giving this request here to say, okay, anything that supports your responses in your interrogatories, I want every document that supports it. And so every answer I get from the interrogatories, now I've got every document that supports it. And again, if they don't give us every document that support it, then they will end up being sanctioned at trial and will probably end up with a mistrial because they do something like that, and they'll be fined significantly for doing it because we're being left without a document they were required to give us. Again, if what was requested is what the document is defined as, then we should get it, and if we don't get it, then the other side gets some real fines and bad circumstances because of it. All right, look at the next one. Please produce documents in your possession, custody, or control which support your responses to the request for admission served concurrently herewith. So they also serves a request for admission along with the interrogatories. And so they're asking, give us all the documents that support your responses to those requests for admission. It's very easy stuff because that's the easy button. That's just everything you ever use to support anything that we're asking you. Send it our way is sort of the request that we're making here. All right, please produce documents in your possession, custody, control which support each affirmative defense which you have asserted in your answer to the complaint against you. Designate which particular defense or defenses you claim which each document produced applies to. This last one's probably objectionable because you're not required to do that in a request for production of documents. You're simply required to produce the documents, not to categorize them by any category for the other side. But please produce documents that support their affirmative defenses. This is a defense. We're a plaintiff, and we're asking the defense for if you have affirmative defenses, you think you're entitled to have done what you did, and you're legally excused for having done so under some affirmative defense. Well, give us every document you have that supports it. Well, that's pretty broad, but it's perfectly acceptable because they're required to give us everything that supports their affirmative defenses. So if we're asking for it, we'll get it, or we should get it anyway. All right, please produce documents in possession, custody, or control which you contend support each allegation in your complaint. So it looks like the defendant also filed a complaint. So we got cross complaints going on here. And so give us every document that you contend supports each allegation in your complaint. So that means that even if they didn't, let's assume that we put down the word just you support or to support the allegations in your complaint rather than contend that you support each allegation. We would only get the ones that are actually supporting it rather than the ones that they may contend to support it. So we're actually, by using the word contend here, we're actually extending out the definition a little bit larger, making a little bit larger haul of documents, because if they contend it supports their complaint, then they have to give it to us. And if they later bring it on in trial and say that it supports their complaint, we didn't get it, they're in trouble. All right, please produce documents in your possession, custody, or control which support your claimed damages. Another broad but very good and substantial request. If you have damages, I want to see all your medical reports. I want to see your the bills from all the doctors. I want to see your prognosis documents indicating what kind of problems you're going to have in the future and what those things are going to cost. And maybe you have an accountant who's been calculating all these damages. We want to see the documents they created to account for all the damages that you think you've got. We want to see all that stuff. And so we get full disclosure of all those documents. It says, please produce documents in your possession, custody, or control which support your claim for physical, mental, or emotional injuries. Another very broad category, but they're asking for physical, mental, or emotional injury, so we get every document that supports it. So if there's emotional injuries here, we may have some bills from some psychiatrist or psychologist giving them therapy and so on and so forth, or whatever it may be, but we're going to get whatever they have, or what everything that they have custody of or they have control over. Let's look at some of the more difficult ones here. Please produce a copy of any and all insurance policies and/or declaration sheets of any and all policies, including excess umbrella policies, providing the nature and monetary amounts of all insurance and indemnity coverage for you and any named insured regarding the insured of the vehicle that caused injuries and damages to the plaintiff in the subject incident. So this is not well worded because they may not agree that their car did in fact cause injuries. So they might say, well, we're not going to give you anything. What they should have said is the one that is claimed to have caused the injuries. And that really what they should have done is put the actual vehicle's name down there, so that they would not, not let them kind of wiggle out of it. But it's at least a good one. Look how broad the language is. This is a very good one, by the way, to use as part of your insurance claim or your insurance request for insurance policies. But you have to tie the insurance policies into ones that either do cover or at least arguably could cover the claims by the plaintiff. So if you say, I want every insurance company or every insurance policy you have, well, first of all, you're going to go back into history. If it's an older person, you're going to go back 40, 50 years for every insurance policy they've ever had of any kind, including medical insurance, what other kind of insurance do you have? Homeowners insurance, auto insurance, boat insurance, life insurance. No, none of those really matter. The only ones that matter are the ones that either do or at least arguably could cover the claims of the plaintiff in the action. Otherwise, we're way too broad, way too broad. We want every insurance policy, but we only want the ones that would at least arguably cover the plaintiff's claim and none other, because otherwise there's nothing that would be relevant to the action or even close to it. We don't want the person's life insurance policy because that doesn't cover anything. That doesn't cover liability for causing injury to somebody, as an example. So these are good examples to use and to go back to these when you're formulating your language to see if they don't help you in formulating your categories. Okay. Now we're looking for anything that would tell us that John Smith is a violent person. That is his character trait for being violent. Perhaps we would be looking for anything that would be a violent incident or evidence of a violent incident, including newspaper reports, police reports, letters, emails, journal entries, anything like that. So we have to now break this down. What kind of evidence would tend to prove someone is a violent person? Again, violent incidents are one. Possibly someone accusing him of being a violent person. What that would do is get us a witness who may have a whole bunch of other information about why they said he was a violent person. That's another category we might want to look for, is any communication from any person to John Smith or someone associated with John Smith that accuses John Smith of being a violent person. Accuses or suggests that he might be a violent person. We can use even more broad language than that. So we want to think about these definitions and think about what it is that we're actually requesting, and make sure first that, of course, that it's going to be something that would be relevant to the action, and his violent propensities could potentially be relevant. And so we're looking for everything like that, but we're not going to look for anything more in terms of every document. So what I typically get, unfortunately, from these requests for documents definitions from students is something like, give me every email. Give me every email in your possession, custody, control. And I think, well, you didn't think past, define. You wanted emails for sure, and that's probably a good way to start. But you didn't limit the emails to something relevant to the action. So if you want every email, you're going to want it that indicates in any way that John Smith is a violent person. Now you're getting somewhere. And you may not just want emails. You want emails, journal entries, police reports, letters, newspaper articles, videotapes, audio tapes, or any other document that does or might suggest that John Smith is a violent person, that kind of thing. And so this is a very creative assignment, but the reason why I'm having you do this is that when you're a paralegal and they ask you to draft up a set of requests for documents in the case, this is exactly what you will be doing. And so if you ask for things like every email they have, your supervising attorney is going to say, well, I don't think we should be having you do this because you really don't understand what you're doing. You don't understand what the nature of these requests are. The wordsmithing that goes into these things is to make sure, again, that you cover a broad enough territory that you're going to cover what is likely to be something they're hiding from us that we want, but not so broad as to cause a viable objection because it's overly broad. That means that it asks for things way outside anything that would be relevant or potentially relevant to the case. So you have to be sure that when you ask for something, you look at it and say, okay, what am I asking for? For every category you write up, what is this category going to do in terms of what kind of documents am I going to get? And then you ask the next question, which is, what would be the... All right, so let's think about one category that we can make up on the issue of the violent person stuff, because we have a pretty good form language here for using insurance. The insurance could only be one request. You can get it all in one request, but the violent thing is going to take several requests. You probably could get 8 to 10 of them if you want to. The first thing you want to do is make it so that it's any document, and you want to make sure that the document is defined as it is in the evidence code, which includes writings, electronically stored information, audio tapes, videotapes, anything where information is somehow fixed into some readable form. And so you'll want to use language such as please produce any and all documents in your possession, custody, or control as a first preamble to any of your requests. Now let's say we want documents that have to do with somebody accusing John Smith of being either violent or suggesting that he's violent as one category of evidence of the fact that he might be a violent person. So what we would want is, again, please produce any and all documents in your possession, custody, control that evidence any person other than yourself suggesting, claiming, or stating that you were either involved in a violent incident or are a violent person. There you go. Now that is that would go back in time as far as when he was a kid, all the way till today. Why? Because if we're looking for character evidence, it's going to be around for pretty much his entire life. If there's evidence of it, it's good evidence. So it's not a matter of time, but it is a matter of that what we're looking for is something that would help us to prove our case, or potentially help us to prove our case, or at least calculated to find evidence that will help us to prove our case. Now the rest of these I'm going to have you people do, because that's your creative effort that you're going to have to do. But I've given you the good preamble type of language that you want to use for each of your requests. We've got a real good similar form language essentially for insurance policies, but you're going to have to make sure that it's having to do with the claim by the defendant against the plaintiff in this case, meaning you're looking for liability insurance where John Smith would have to pay Jeffrey Jones in the case, and so you'll have to make sure that the insurance language is in connection with that kind of claim. So you don't want every insurance policy this guy has, but you want everyone that could or claims to or could possibly insure Jeffrey Jones for the activities of John Smith on the day in question. Okay, so now the rest of it's going to be up to you. So I want to leave that to you to make up these lists. Now, again, if you're having any problems, please feel free to give me a call. I'll be more than glad to help you. I will not create your language for you because that's what you need to do. but I will make suggestions on how to do it. And if you give me some of your requests before you turn them in, I will be willing to tell you, oh, wait a minute, that's too broad, it's too narrow, it's that kind of a thing, and so you need to redo the language. I won't help you to redo the language, but I will tell you whether it is too broad, too narrow, or whether there's anything else wrong with it, so that you can get a good grade on this assignment. All right, and it's also something you really want to learn because as a paralegal in a litigation firm, if you can't make up requests for documents that are appropriate after a few years of experience as a paralegal, you're probably not going to do well in a litigation firm because so much of your duties have to do with all the different aspects of discovery, including requests for documents and other requests like interrogatories and so on. So that's why we do it in this class. All right, so that's it for this assignment. If you have any questions, again, please feel free to give me a call.